Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Welcome to Angeion's Leading Litigator video series. Today it is our pleasure to have Paul Karlsgodt joining us from BakerHostetler. He is the leader of their national class action defense practice. Thanks for joining us, Paul.
Thanks for having me, Steve.
So, Paul, you and I have had the opportunity on several occasions to discuss settlements in general, and that's sort of where I was hoping our conversation would lead today. One of the things in particular that we've discussed is sort of the increased scrutiny that courts are giving settlements, especially around sort of claims-made settlements and non-cash settlements. But I really want to talk about claims-made settlements because you had said something to me prior about how they're really an excellent candidate for the type of litigation that you're known for, which is class action data breach defense. So I was hoping you could sort of share with our viewers your view on that and let us know what you think.
Yeah, so what I found over time is that claims-made settlements are a good way to settle certain types of class actions. They're not the best structure for all kinds of settlements, but they work particularly well in situations where there are a variety of different types of injuries or damages that individuals might be claiming, but you don't know in advance what those injuries are. And that is particularly the case in data breach class action settlements. And even more true in certain types of data breach cases, particularly those involving payment cards. There's a laundry list of different types of injuries that you can think of being possible as a result of someone having their credit card misused. And they include things like I was overdrawn on my account for some period of time and I had to pay interest, or I had to mail in using postage a payment that I would normally make using my credit card. Very small damages items, but arguably things that an individual might want to recover as part of a lawsuit. And so by making a claims-made structure, you can make available the ability to claim in those things without knowing exactly what any individual might be claiming. And it's in that context where you have sort of an unknown within a class of people who really self-identifies as even being damaged. Right. Where a claims-made settlement provides the best structure because you don't have to set aside a certain amount of funds and have a lot left over that you either have to pay to charity as a cypre distribution or pay pro rata to people that wouldn't even self-identify as having damages.
No, that's helpful. To your mind, are there any categories of damages that do sort of extend in the data breach context across all class members, or is it all sort of the individualized inquiry that you just talked about, apprehension, fear, those types of arguments that you hear plaintiffs' counsel make? Are those appropriate for? Well, first, do you believe they are universal, and should they be treated as such, or are we primarily in the claims-made sort of paradigm?
Well, it's interesting. Even those cases that have settled with a common fund structure. Almost all of them, to my knowledge, have involved some sort of a claims process where people are making claims for actual out-of-pocket losses. Right. Many also provide for things like credit monitoring, which could be a one-size-fits-all remedy in a data breach class action. But going back to the example of payment cards, using credit monitoring as a remedy for a payment card breach is really a square peg in a round hole problem. Because if all that's affected in a data breach is your credit card number, the kinds of things that credit monitoring provide aren't going to protect you from a misuse of that credit card number. There's really one thing that fixes it, and it's often done right away after there's been a payment card breach, and that's replacing the card. Right. And so there are some kinds of remedies like that that could be provided on a class-wide basis, but in certain cases they don't make any sense. And with particular reference to payment card cases, providing credit monitoring may provide people with an irrational peace of mind. Right. It may be a real belief, but it's misguided because that kind of credit monitoring doesn't really help their problem.
No, that's a valid point, and I think that gets lost sometimes on the masses. You feel good that you have this credit monitoring in place, but you've already got a new card. That card number's out of circulation. They don't have any other personally identifiable information. Right. What does that credit monitoring really do? When do we see an objection on that point?
Well, I think that the problem that you see in all settlements, and this is really across the board right now, is this additional judicial scrutiny that we're seeing with judges really trying to compare what the plaintiff's attorneys are getting in terms of a fee award, comparing that to the benefit that's actually being provided to the class. And you see that more often. What it creates is it limits the options that parties have to resolve a case for the benefit of everybody who really cares about it. Right. In a claims-made settlement, you can provide the ability to make a claim for anyone who wants to participate and is willing to do the minimal effort required to fill out a claim form. It provides for the attorneys on the plaintiff side to get paid. It provides peace for the defendant. Anyone who really cares about what's at issue in the case is made whole or given relief in a claims-made settlement. But unfortunately, there's enough judges out there now who are really looking at not wanting to approve the fee component unless they see some sort of commensurate benefit to the class. And so typically when you see an objection in any claims-made settlement, it's based on this idea that the amount that's actually going to be distributed at the end of the day to class members is disproportionately small as compared to the amount of the fees that are being paid.
Right, and there's been arguments that the opportunity to claim that full amount is what it should be based against versus how many people actually do claim. But the other sort of argument that I'm seeing, and not necessarily in the data breach context, it's coming out mostly in the Ninth Circuit, especially in light of the Ninth Circuit's guidance for class actions, is that if you have name and address, you should be sending checks irrespective if someone raises their hand and said, I was aggrieved. And philosophically, I'd be curious your position on that. Just not as it relates to data breach in particular. I mean, look at it in the auto context. I've seen it come up in the auto context. I mean, do you have any thoughts on that?
Well, I think typically the defendant's response to that is there's more of a potential for fraud when you're making direct payments because you don't know where the check is going, even if you think you have a good address for somebody. But that having been said, there are some courts that have said, look, if the settlement benefit that's being made available is the payment of cash, money, then you should give them the money directly. You shouldn't make them claim it. Right. That may be true in certain cases where the appropriate benefit for a settlement is simply a dollar amount cash payment that is the same for everybody. Right. In a data breach case, though, as we talked about before, there's a large variation in two things. One, who even self-identifies as having been damaged by the incident? And two, if they do self-identify, what is that amount? And so in that context, it's very difficult unless you're just going to agree as a defendant, and you can, it's a settlement, agree to pay everybody the same, then you have to have some sort of a process where a claim can be made. And it also addresses another problem that can come up, and that is this sort of the AmChem versus Windsor problem, where if you are making, say, $100 available to everybody, but there are people in the class that may actually claim damages of $10,000, then the kind of settlement where you have to pay everybody the same amount isn't really fair. Right. And so courts may have sort of the opposite problem in that setting. And so there's always going to be a role in class action settlements generally for claims processes. There are certain cases where it may be appropriate to make direct payments, but in many cases there still is a need for people that individually have to make it.
No, I agree, but I think there is a good deal of discretion across the spectrum as to when it's appropriate and when it isn't. Going back to the AmChem problem, isn't that the reason that Rule 23 provides for opt-outs, though, or at least isn't that an argument?
Well, I think that's an argument that was made in the AmChem case, and the Supreme Court said that's not enough. I think what you see in practice is there are certain types of cases where the variation in the existence of injury and damages is there, but it's not so great that the court isn't willing to overlook it for the sake of allowing the parties to resolve the dispute. There are other cases, and asbestos or tobacco-related injuries are probably the best example. AmChem involved asbestos, where the courts have said no. The existence of and degree of injury is too great to allow the class action mechanism to be used as the way of resolving.
Right. So you talk about variation, and it brings to my mind two things. It brings to my mind, one, that we're seeing an increased sort of legislative fix to some data breach stuff. California has new laws on the counter, or on the books, I should say. And then at the same time, you have the Ninth Circuit Hyundai-Kia case. And to your mind, how do those intersect, and is it going to be a problem for data breach settlements in the future?
It's interesting. A problem for data breach settlements and any kind of settlement right now is presented by the Hyundai decision. It remains to be seen how the courts are ultimately going to be applying it. On its face, Hyundai really just requires the district court to consider the potential of varying legal principles applying to different class members in different states. It doesn't necessarily say that you can't have a nationwide settlement. It requires a little more scrutiny over that. It's conceivable that that will reduce the ability of certain parties to have nationwide settlements and class actions, which then increases the amount of cost associated with litigating them, because now you, instead of having one single case, you have to have 20, 30, maybe 50 different cases. So that does present a potential issue. It remains to be seen whether, as a practical matter, it'll be more than simply requiring the parties to put a little bit more effort into explaining why the class settlement is fair, despite the possibility of different laws applying in different places. But you combine that with very specific state laws providing for specific remedies. And I think as a practical matter, you already see in those situations plaintiffs tending to file those cases as just statewide class actions under those statutes. And so in particular, right now, we've seen a wave of litigation under the Illinois Biometric Information Privacy Act, or BIPA, as I call it. And then the California privacy law is brand new. It remains to be seen what kind of litigation it'll generate. It does have a safe harbor that requires notice be given to the defendant before a class action can be filed and an opportunity to cure. So, but there is a possibility that the emergence of those types of state laws without a kind of a single federal privacy law that supersedes everything will create much more state-specific litigation and less national litigation.
Do you think we will eventually see national legislation on the privacy in the data breach context?
I have no idea. That's one of those issues that comes up all the time. With today's political climate, you ask me whether any particular legislation has the ability to pass, and the answer is I have no idea. But it is certainly something that you tend to see and historically have seen in the United States be something that states deal with, as opposed to there being a single federal standard. What we have tended to see in federal laws are federal laws that are really specific to a particular kind of problem. For example, the Telephone Consumer Protection Act, dealing with potentially offensive telephone communications. Whereas more general privacy laws have tended to be the provenance of state law.
Paul, I can't thank you enough for coming here today, sharing your views. There are very few people in the country who know this type of law with the breadth and depth that you have, and it's been our honor to have you here. Thank you.
It's been my pleasure, Steve. Thank you very much for having me.